तो जी अब हम लोग दोबारा से लाइव आ गए हैं। आई एम गोइंग टू शेयर माय स्क्रीन विद यू और आई होप सो कि सबको स्क्रीन जो है वो नजर आ रही होगी। यहाँ पे हम लोगों ने इस वीडियो में हम लोगों ने कवर करना है अपना बोर्ड ऑफ डायरेक्टर्स को। ठीक है, एक लेंथी फाइल है हमारे पास और ये हम लोगों ने कंप्लीट करनी है इस लाइव लेक्चर में इंशाल्लाह। इसके अंदर हम लोगों ने देखना है ऑफिसर includes any director, chief executive, chief financial officer, or a company secretary. A company director is appointed to a company to manage the day-to-day business activities and finances and to ensure all statutory filing obligations are met. Directors must act lawfully and honestly and make decisions for the benefit of the company and its members, directors, or both. Trustee and agent of the company. Companies Company law defines director. Director includes any person occupying the position of a director by whatever the name called. Types of companies director. इसके लिए कुछ मैनेजिंग डायरेक्टर, एग्जीक्यूटिव, ऑर्डिनरी, प्रोफेशनल, ऑल्टरनेटिव और नॉमिनी डायरेक्टर। तो ये सब हम लोगों ने फिर वन बाय वन देखना है। फुल टाइम डायरेक्टर्स, they are full time employee of the company. They look after all the aspect of the company. Full-time director means a director employed to devote the whole of his time and attention in the carrying on of the affairs of the company. Executive director. The executive director is appointed by the board of directors and works with the board to develop a strategic plan for the organization. As leaders, executive directors must create the culture of the organizations. They are the foundation of motivating employees and volunteers, oversee the entire budget and marketing efforts, and encourage a positive company culture. A non-executive director means a person on the board of the company who is not formed among the executive management, a team, and may or may not be independent. This is expected to lend out outside viewpoint of the board of a company, does not undertake to devote his whole working time to the company and not involved in managing the affair of the company, is not a beneficial owner of the company or any of its associated companies or entities, does not draw any remuneration from the company except the meeting fee. Independent director. An independent director means a director who is not connected or does not have any other relationship, whether financial or otherwise, with the company, its associated companies, subsidiaries, holding company, or director. And he can be reasonably perceived as being able to exercise independent business judgment without being subservient to any form of conflict of interest. Protection to independent and non-executive director. An independent director and a non-executive director shall be held liable only in respect of such acts of omission or commission by a listed company or a public sector company which had occurred with his knowledge attributable through board processes and with his consent or convenience or where he had not acted diligently. Minimum number of directors of a company. A single member company shall have at least one director. Every other private company shall have one, not less than two directors. A public company shall have not less than three directors. A listed company shall not have less than seven directors. Only an extra person shall be a director. Number of directorship. A person shall not hold office as a director at a time in more than such number of companies as may be specified after the commencement of the act. Limit shall not include the directorship in a listed subsidiary. A person holding the position of the director is in more than seven companies on the commencement of this act shall ensure the compliance of this section within 1 year of such commencement. Eligibility for directorship and election of directors. First directors and their term. The number of directors and their names of the first directors shall be determined by the subscribers of the memorandum and shall be submitted along with the documents of their incorporation of the company. The number of first directors may be increased by appointing additional directors by the members in the general meeting. The first director shall hold office until the election of the directors in the first annual general meeting of the company. Ineligibility criteria for the persons to become a director. A person should not be eligible for appointment as a director of a company if he is a minor, is of some unsound mind, has applied to be executed adjudicated as an insolvent and his application is pending. He is an undischarged insolvent. Has been convicted by a court of law for an offense involving moral tribute. Has been debarred from holding such office under any provision of Companies Act 2017. Is lacking fiduciary behavior and a declaration to this effect has been made by the court under Section 212 at any time during the preceding 5 years. Does not hold NTN number as per the provision of Income Tax Ordinance 2001. Is not a member. Has not declared by a court of competent jurisdictions as defaulter in repayment of loan to a financial institution. Is engaged in business of brokerage pertaining to securities market as defined in the Securities Act 2015. अब जैसे कि आप लोग को पता ही है कि इस नॉट अ मेंबर की कुछ एग्जाम्पशंस भी हैं और हम लोगों ने अब उसको आगे चल के देखना है. पहले उसकी देखेंगे हम इन एलिजिबिलिटी ऑफ बैंकक्रप्ट टू act as director. If any person being an undischarged insolvent act as chief executive or director of a company, he shall be liable to imprisonment for a term not exceeding 2 years or to a fine not exceeding 100,000 rupees or both. Non-member can be appointed as director. और ये उस ऑप्शन की एक्सेप्शन है यहाँ पे. Under following circumstances, a non-member can be appointed as a director of a company where a person representing a member, which is not an extra person, a whole team, whole nine director who is an employee of the company, a chief executive, or a person representing a creditor or other special interest by a virtue of contractual agreement. Penalty for unqualified person acting as a director. If a person who is not qualified to be a director or chief executive or who has otherwise vacated the office of director or chief executive describes or represents himself or acts as a director or chief executive or allows or causes himself to be described as such shall be liable to a penalty of level 1 to the standard scale. After this, there is a requirement to conduct election for the subsequent directors. The directors who continue to perform their functions shall take immediate steps to hold the election of directors in case of any impediment. Report such circumstances to register within 45 days before the due date of the meeting in which elections are to be held, and the holding of general meeting shall not be delayed for more than 90 days from the due date of the meeting or such extended time as may be allowed by the registrar for reasons to be recorded only in case of exceptional circumstances beyond the control of the directors or in compliance of any order of the court. The registrar may, on expiry of such period, either on its own motion or on the representation of the members holding not less than one-tenth of the total voting powers in a company having share capital, or on the representation of members holding not less than one-tenth of the total members of the company not having share capital of the company, directs the company to hold annual general meeting or extraordinary general meetings for the election of directors on such date and time as may be specified in the order. Now there is a procedure for election for directors is given there. We have to discuss it. The existing director of a company shall fix the number of the directors to be elected in the general meeting not later than 35 days before convening of such meeting. The number of directors so fixed shall not be changed except with the prior approval of the general meeting in which election is to be held. The notice of meeting at which directors are proposed to be elected shall, among other matters, expressly state the number of directors fixed and the names of the retiring directors. Any member, whether he is a retiring director or otherwise, who seeks to contest an election to the office of director shall file with the company a notice of his intention to offer himself for election as a director not later than 14 days before the date of the meeting at which elections are to be held. Any person may, at the time before holding of election, withdraw such notice. All notices received by the company shall be transmitted to members not later than 7 days before of the meeting. In the case of the unlisted company, notice shall be published in English and Urdu languages, at least in one issue each of a daily newspaper of respective language having wide circulation. Here is the notice is given of AGM. Okay, now we have to be the conduct of election director of a company having share capital. If the number of persons who offer themselves to be elected is equal to the number of directors fixed, then all such persons shall stand so elected in general meeting. If the number of persons who offer themselves to be elected in more than the number of directors fixed shall be elected by the members of the company in general meeting in the following manner, namely: first of all, a member shall have such number of votes as is equal to the product of the number of voting shares or securities held by him or the number of directors to be elected. A member shall give all his votes to a single candidate or divide them between more than one of the candidates in such manner as he may choose, and the candidate who gets the highest number of votes shall be declared elected as director, and then the candidate who gets the next highest number of the votes shall be so declared, and so on until the total number of directors to be elected has been so elected. Directors of the company limited by guarantee and not having share capital. The directors of the company limited by guarantee and not having share capital shall be elected by members of the company in general meeting in manner as provided in articles of association of the company. Consent to act as director to be filed by the company. A person shall not be appointed or nominated as a director or chief executive of a company or respect or represent as holding such office unless such person has given his consent under Form 28 in writing to the company for such appointment or nomination. The consent given to the company under subsection 1 shall be annexed to the relevant form reporting the appointment of director or chief executive as the case may be. Here's the power of vote re-election of directors and prohibition for certain acts. Power of court to declare election of directors invalid. The court may, on application of members holding at least 10% of voting power in the company and made within 30 days of the date of election, declare election of all directors or any one or more of them invalid. The court may declare such election as invalid if it is satisfied that there has been material irregularity in the holding of elections and matters accidental or relating thereto. Fresh election of directors in case of unlisted companies after the election of directors if a member acquire the requisite shareholding to get him elected as a director on the board of a company, then such member may require the company to hold fresh election of the directors in accordance with the procedure laid down in section 159, provided that the number of directors fixed in the preceding election shall not be decreased. The board shall appoint recipient of requisition within 30 days proceed to hold fresh election of directors of the company. Retirement of first and subsequent directors. All directors of the company on the date of first annual general meeting, in case of subsequent directors on expiry of term of office, directors shall stand retired from office. The directors who retire shall continue to perform their function until their successors are elected. The directors who continuing to perform their functions shall take immediate steps to hold the election of directors in case of any obstacle report such circumstances to registrar within 45 days before due date of the annual general meeting or extraordinary general meeting as the case may be in which elections are to be held. Term of office of directors. A director elected shall hold office for a period of 3 years unless he earlier resigns. Vacates office due to fresh election required become disqualified from being a director or otherwise ceases to hold office. The term of office of directors of a company limited by guarantee and not having share capital may be a period of less than 3 years as provided in the articles of the association of a company. Any casual vacancy occurring among the directors may be filled up by the directors, and the person so appointed should hold office for a remainder of the term of the director in whose place he is appointed. Any casual vacancy on the board of a listed company shall be filled up by the directors at the earliest but not later than 90 days from the date the vacancy occurred. Okay, so the next one is there. Prohibition on assignment of office by directors. A director of any company shall not assign his office to any other person, and any such appointment shall be void ab initio. The appointment of a director with the approval of the board of an alternate or substitute director to act for him during his absence from Pakistan of not less than 90 days shall not be deemed to be an assignment of office. The alternate director appointed shall ipso facto vacate office if and when the director appointing him returns to Pakistan. Restriction on directors' remuneration. The remuneration of a director for performing extra services, including the holding of the office of chairman, shall be determined by the board or the company in general meeting, as the case may be, in accordance with the provisions of the company's articles. The remuneration to be paid on any director for attending the meetings of the board or a committee of directors shall not exceed the scale provided by the company or the board, as the case may be in accordance with the provisions of the articles. Vacation of office by the directors. A director shall ipso facto cease to hold office if he becomes ineligible to be appointed as a director on any one of more the grounds enumerated in section 153. He absents himself from 3 consecutive meetings of the board without seeking leave of absence. He or any firm of which he is a partner or any private company of which he is a director without the sanction of the company in general meeting except to hold any office of profit under company or other than the chief executive or, or a legal or technical advisor or accepts a loan or guarantee from the company in a contravention of section 182. Validity of acts of directors. The acts of a director, the acts of a person acting as a director are valid even if it is afterwards discovered that there was a defect in his appointment or he was disqualified from holding office. He had ceased to hold such office, provided that as soon as any each as soon as such defect has come to notice, the director shall not exercise the right of his office till the defect has been removed. Removal of directors. A company may, by resolution in general meeting, remove a director appointed or elected under Companies Act 2017. A resolution for removing the director shall not deem to have passed if the number of votes cast against it is equal to or exceeds the number of votes for the time being computed in the manner laid out in the section divided by the number of directors for the time being. If, if the resolution relates to removal of a director appointed or where the directors were elected unopposed, or the minimum number of votes that were cast for the election of a director that the immediately preceding elections of directors, if the resolution relates to removal of a director elected in the manner provided. Proceedings of Board of Directors. Proceedings of the Board of Directors. The quorum of a meeting of board of a listed company shall not be less than the one-third number of the directors or four, whichever is greater. The participation of directors by video conferencing or by other visual means shall also be counted for the purposes of quorum. If at any time there are not enough directors to form a quorum to fill a casual vacancy, all the remaining directors shall deem to be constitute a quorum for this limited purpose. The quorum for a meeting of the board of other than a listed company shall be as provided in the articles. The board of the public company shall meet at least once in each quarter of a year. If a meeting of a board is conducted in the absence of quorum or a meeting of board is not held as required, the chairman of the directors shall be liable. If the default relates to a listed company, penalty of level 2 of the standard scale. If the default is related to another company, to a penalty of level 1 on the standard scale. Passing of resolution by the directors through circulation. A resolution is in writing approved by all the directors or the committee of directors for the time being entitled to receive notice of a meeting of the director or committee of the directors shall be as valid and effectual as if it had been passed at meeting of the directors or the committee of the directors duly convened and held. A resolution shall not be deemed to have been duly passed unless the resolution has been circulated together with the necessary papers, if any, to all the directors. A resolution shall be noted at a subsequent meeting of the board or the committee thereof, as the case may be, and made part of the minutes of such meeting. The directors' agreement to a written resolution passed by the circulation once approved may not be revoked. Records of resolutions and meetings of board. Every company shall keep records comprising all resolutions of the board passed by circulation, all the minutes of all proceedings of the board meetings or committees of directors, along with the names of participants to be entered in properly maintained box, minutes recorded to be authenticated by the chairman of the meeting or by the chairman of the next meeting shall be evidence of proceedings at the meeting. Until the contrary is provided, every meeting of the board or committee of the directors in respect of the proceedings thereof minutes have been so made shall be deemed to have been duly called, held, or conducted. A copy of the draft minutes of the meeting of the board shall be furnished to every director within 14 working days of the date of meeting. The records must be kept at the registered office of the company from the date of the resolution meeting or decision simultaneously in physical and electronical form, and it shall be preserved for at least 10 years in physical and permanently in electronic form. Any contravention or default in complying with requirement of this section shall be an offence liable to a penalty of level 1 in on the standard scale. Loans to directors. Requirements of members' approval. A company shall not make a loan to a director of the company or of its holding company or to any of its relatives. Give a guarantee or provide security in connection with a loan made by any person to such a director or to any his relatives. This section shall apply to the loan provided to a chief executive or the whole-time director subject to the condition that the loan is granted under a scheme provided by the members of the company. In case of a listed company, approval of the condition shall also be required before sanctioning of any such loan. For the purpose of this section, relative in relation to a director means this his spouse and minor children. This section shall not apply to a company which is which in the ordinary course of thus its business provides loan or gives guarantees or securities for the due repayment of any loan. Every person who is a party to any violation of this section, including in particular any person to whom the loan is made or who has taken loan in respect of which the guarantee is given or the securities provided shall be punishable with fine which may exceed to 1 million rupees or with simple imprisonment for a term which may extend to 1 year. All persons who are parties to any violation shall be liable jointly or severally to the lending company for the repayment of the loan or for making good and sum with markup not less than the borrowing cost of the lending company, which lending company may have been called upon to pay by virtue of the guarantee given or the security provided by such company. Prohibition regarding making of political contribution. A company shall not contribute any amount or allow a utilization of its assets to any political party for any political purpose to any individual or body if a company contravenes the provisions of subsection, then the company shall be liable to a penalty of level 2 on the standard scale. And every director and officer of the company who is in default shall be punishable with imprisonment of either description for a term which may exceed to 2 years and shall also be liable to a fine of 1 million rupees. Prohibition regarding distribution of gifts. A company shall not distribute gifts in any form to its members in its meeting. Any contravention or default in complying with requirements of this section shall be an offence liable to a penalty level 1 on the standard scale. Contracts and agreements with directors. Contract of employment with the director. Every company shall keep at its register office where a contract of service with a director is in writing, a copy of contract where such a contract is not in writing, a written memorandum setting out its terms. The copies of a contract or memorandum shall be open to inspection by any member of the company without payment of fee. Any contravention or default in complying with requirement under this section shall be an offence liable to a penalty of level 1 or the standard scale. The provision of this section shall not be applied to a private company. Register of directors, officers. Every company shall keep its registered office, a register of its directors and officers, including the chief executive, company secretary, chief financial officer, auditors, and legal advisors pertaining with respect to each of them such particulars as may be specified. Every person referred above shall, within a period of 10 days of his appointment or any change herein furnished to the company the particulars specified. Every company shall, within a period of 15 days from the date of appointment of any person referred above, or any change among them, or any of their particulars, file with the registrar and return in specified form. With this subsection shall not apply to the first appointment made at the time of incorporation of the company. If the name of any person is fraudulently or without sufficient cause entered in or omitted from the registrar of directors of a company, or the person aggrieved or the company may apply to the court for ratification of the registrar of directors. The court may either refuse the application or may order ratification of the registrar on such terms and conditions as it may deem fit and may make order as to cost. When the court has passed an order under subsection that prima facie or entry in or omission from the registrar of directors, the name or other particulars or any person was made fraudulently or without sufficient cause, the court may send a reference for adjunction of the offence under subsection 8 to the court as provided in section 482. Anyone who fraudulently or without sufficient cause enters in or omits from the registrar of directors. The name or other particulars of any person shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which may extend to 1 million rupees, or with both. It makes an order for ratification of the Register of Directors in respect of a company. The board shall cause a copy of the order to be forwarded to the company and shall by its order direct the company to file notice of the ratification with registrar within 15 days from the recipient of the order. Rights to inspect. The, re- the register kept under Section 197 shall be open to the inspection of any member of the company and of any person during business hours subject to such reasonable restrictions as the company may impose by its articles or in general meeting, so that not less than 2 hours in each day are allowed. Inspection by any member of the company shall be without charge, and in the case of any person on payment of such fee as may be specified by the company for each inspection. A person seeking to exercise the rights conferred by this section must make a request to the company so that effect. The request must contain the following information: in the case of an individual, his name and address. In case of an individual, his name and address. In case of an organization, his its name and address, and also of the authorized person and the purpose for which the information is to be used. In case of any inspection is refused, the registrar or application made by the person to whom inspection has been refused and upon notice to the company may by order direct and immediate inspection of the register. Any contravention or default in complying with the requirements of this section shall be an offence, shall be liable to a penalty of level 1 on the standard scale. Disclosure of interest by director. Every director of a company who is whether directly or indirectly concerned or interested in any contract or agreement entered into or to be entered into by or on the behalf of the company shall disclose the nature of his concern or interest at a meeting of the board. The director shall be deemed also to be interested or concerned if any of his relatives is so interested or concerned. Director's relatives are director's spouse, director's children, including the stepchildren, and director's parents. The disclosure required to be made by a director shall be made in the case of a contract or agreement to be entered into at the meeting of the board at which the question of entering into the contract or agreement is first taken into consideration, or if the director was not on the date of that meeting concerned or interested in the contract or agreement at the first meeting of the board held after he becomes so concerned or interested. In the case of any other contract or agreement at the first meeting of the board held after the director becomes concerned or interested in the contract of agreement. A general notice given to the board to the effect that director is a director or a member of a specified body, corporate, or a partner of a specified firm is to be regarded as concerned or interested in any contract or arrangement um, which may, after the date of the notice, be entered into that body, corporate, or firm shall be deemed to be a sufficient disclosure of concern or interest in relation to any contract or agreement so be it. Any such general notice shall expire at the end of the financial year in which it is given, but may be renewed for a further period of one financial year at a time by a fresh notice given in the last month of the financial year in which it would otherwise expire. No such general notice and no renewal, therefore, there shall be of effect unless there either it is given at a meeting of the board or the director concerned takes reasonable steps to ensure that it is brought up and read at the first meeting of the board after it is given. Any contravention or default in complying with requirements of Section 1 or 2 shall be an offence liable to a penalty of level 1 on the standard scale. Related party transactions. A company may enter into any contract or agreement with a related party only in accordance with policy approved by the board. Every contract or agreement entered into shall be referred to in the board's report or the shareholders along with the justifications for entering into such contract or agreement. Contracts or agreements entered by the director or employee with board's consent or special resolution in general meeting shall be ratified in 90 days. If not ratified, then such contract or agreement is voidable at the option of the board. In case of such transaction is with a related party to director or is authorized by the other director, the concerned directors shall indemnify the company against the loss incurred by it. Company can proceed for recovery of loss from director or employee who has entered into such contract or agreement. Transaction may be any of following: sale, purchase, or supply of goods or materials, selling or otherwise disposing or buying property of any kind, leasing of a property of any kind, availing or rendering of any services, appointment of any agent for purchase or sale of goods, materials, services, or property, and such related parties' appointment to any office or place of profit in the company, its subsidiary company, or associated company. This section shall apply to any transaction entered into the company in its ordinary course of business on an arm's length basis. Arm's length transactions means a transaction between two related parties that is conducted as if they are unrelated. Any director or any employee of a company who had entered into or authorized the contract or agreement in violation of provisions of this section shall be liable. In case of listed company, be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 5 million rupees, or with both. In case of any other company, a penalty of level 2 to the standard scale. On standard scale, there related party includes a director or his relative, a key managerial personnel or his relative, a firm in which a director, manager, or his relative is a partner, a public company in which a director or manager is a director or holds, along with his relatives, any share of its paid up share capital, any body corporate whose chief executive of or manager is accustomed to act in accordance with advice, directions, or instructions of a director or manager. Any person on whose advice, directions, or instructions a director or manager is accustomed to act, provided that nothing in some clauses shall apply to advice, directions, or instructions given in a professional capacity. Any company which is a holding or subsidiary or any associated company of such company, a subsidiary of of a holding company to which it is also a subsidiary, such other person as may be specified. For the purpose of this section, relative means spouse, siblings, and lineal incidents and descendants of a person. Interested director not to participate or vote in proceedings of board. A director of a company who is concerned or interested in the contract or agreement shall not take part in discussion of or vote on any such contract or agreement entered into or to be entered into. His presence his presence shall not account for the purpose of forming a quorum at the time of any such discussion or vote, and if he does vote, his vote shall be void. The director of a listed company who has a material personal interest in a matter that is being considered at a board meeting shall not be present while the matter is being considered. If majority of the directors are interested in any contract or agreement entered into or to be entered into by or on the behalf of the company, the matter shall be laid before the general meeting for approval. This section shall not be applied to a private company which is neither a subsidiary nor a holding of a public company. Any contract or any contract of indemnity or insurance coverage executed by the company in favor of interested director against any loss which he may offer or incur by reason of becoming or being a security for the company or while undertaking any transaction on behalf of the company. Register of contracts or agreements in which directors are interested. Every company shall keep one or more registers giving separately for the particulars of all contracts or agreements in such manner and containing such particulars as may be specified by the Commission. Every director shall within 30 days of his appointment or resignation of his office disclose to the company the particulars relating to his concern or interested in other associates which are required to be included in the register. The register shall kept the registered office of the company and shall be opened for the inspection at such office during the business hours and extracts may be from where I'm reading from and extracts may be taken therefrom and copies thereof as may be required by any member of the company shall be furnished by the company to such extent in such manner and on payment of such fees as may be specified. The register shall also be produced at the commencement of every annual general meeting of the company and shall remain open and accessible during the continuance of the meeting to any person having the right to attend the meeting. This section shall not apply to any contract or agreement for the sale, purchase, or supply of any goods, materials, or services if the value of such goods and materials or cost of such services does not exceed 5 500,000 rupees in the aggregate in any year, or by a banking company for the collection of bills in ordinary course of its businesses. Any contravention or default in complying with requirements under this section shall be offence liable to a penalty of level 1 to the standard scale. And the last one is there disclosure members of directors interested in contract appointing chief executive or secretary. Every director of a company who is in any way, whether directly or indirectly concerned or interested in any appointment or contract of the appointment of a chief executive, full-time director or secretary of a company shall disclose the nature of his interest or concern at a meeting of the board in which such appointment or contract is to be approved. The interested director shall not participate or vote in the proceedings of the board. All contracts entered into by a company for the appointment of a chief executive, whole-time director or secretary shall be kept at the register office of the company. Every contract required to be kept must be open to inspection by any member of the company without charge. Any member of the company is entitled on request or and on payment of such fee as may be fixed by the company to be provided with a copy within 7 days of such contract. And that's it. Our director's chapter have been completed. Now let's meet on the other live session of about which will be about listed companies. Yeah, which will be about listed companies regulation. And the next session will be started after at least 10 to 15 minutes. Allah Hafiz.